All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale international est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please call the case.
Thank you, Mr. President. The situation in the Republic of Kenya in the case of the prosecutor against William Samuel Ruto and Joshua Arap Sang. ICC 0109-0111. We are in open session.
Thank you very much. Appearances?
Morning, Your Honours. For the prosecution, appearances remain the same.
Good morning, Your Honours. For the victims, our appearance remains the same. Thank you.
Good morning, Your Honours. Mr. Sang's team remains the same. Mr. Sang, whose birthday is today, is present.
Mr. President, the defence team for Mr. Ruto remains the same. I do note that he's been excused.
Announcements. On Thursday, we will be sharing this courtroom with the Ntaganda case for their status conference. That means we will not be sitting during the morning hours. We will, in the course of today, announce a revised schedule for Thursday with the hope of capturing as much as possible lost time. So we will be announcing rather a revised schedule for Thursday in the course of today. We will now render a ruling on the disclosure requests made by the Sang defense and joined in by the Ruto defense. During the hearing on Monday, the 1st of September 2014, the Sang defense complained that they had tried in vain to obtain from the Victims and Witnesses Unit disclosure of the financial assistance that the unit has given to Witness 604. On the 3rd of September 2014, the Sang defense filed their application for disclosure of assistance and benefits provided by the VWU to not only Witness 604, but also to Witnesses 495, 516, and 524, all of whom have been summoned to testify before the chamber by video link. The information requested pertains to all expenses related to protection, accommodation, education, healthcare, transport, and communication assistance given to the witnesses or their dependents. The Sang defense requests that the disclosure be made directly to them or to the chamber. The Sang defense submits that the requested information is potentially relevant to the credibility of the witness, thus potentially exculpatory. I should say credibility of the witnesses, in that it might explain the witnesses' motivation to cooperate with the prosecution. The Ruto defense fully supports the arguments made by the Sang defense in their application. Additionally, the Ruto defense submit that the request is meritorious even as a request for reconsideration of the Chamber's previous decision rendered on the 28th of October 2013 on a similar request for disclosure. According to the Ruto defense, the situation of the four witnesses concerned in the current request present new facts or circumstances and compelling new information which warrant reconsideration of the earlier ruling. The prosecution opposes the request, arguing that the Chamber, in its oral ruling of the 28th of October 2013, had already addressed the underlying defense arguments made in the current request. The decision engages a principle of general application also pertaining to other witnesses. Additionally, the prosecution submit that there is no compelling new information warranting reconsideration because the Sang defense has not made out a case to the effect that the payments made by the VWU to the witnesses were unreasonable or improper. However, the prosecution suggests that if there is any doubt about the reasonableness of the payments, the information could be provided to the Chamber to enable the Chamber assess for itself the potential of the material to be exculpatory. In its submissions, the VWU stresses that as a neutral unit of the court, it ensures that all allowances and support are provided without regard to the party calling the witness. No consultations are undertaken with any party in the process of determining the assistance that the VWU considers necessary and appropriate for the witness. Further, the VWU submits that it does not, in principle, share details of expenses at the instance of witnesses, as this information could lead to the identification of the witnesses and reveal the working practices of the unit. The VWU offers, however, that they stand ready to make the information available to the Chamber at the direction of the Chamber. The Victims' Council submits that the quantum of assistance provided to each witness and the reasonableness of the assistance has to be assessed for each witness individually if it is supposed to form part of the witness's credibility assessment. It is recalled that on the 28th of October 2013, the Chamber gave an oral decision on the request of the Ruto defense and the Sang defense for, among other things, disclosure of all costs expended by the VWU for purposes of relocation, maintenance, and or support of Witness 268 within the Witness Protection and Support Program. The Chamber denied that request for the following reasons, amongst others. But in the Chamber's view, the probative value of granting the request is outweighed by both the considerations of prejudice and efficiency, not only in relation to the witness, but also the operations of the Victims and Witnesses Unit and the administration of justice in general. Witnesses who come to testify, it is presumed, will have to have sustenance in their lives, whether it is afforded to them on their own or through the instrumentality of the Victims and Witnesses Unit. It therefore does not afford a prima facie indicium of credibility that the Victims and Witnesses Unit has undertaken those reasonable tasks of providing reasonable support and maintenance to a witness rather than the witness doing it themselves, unquote. While the ruling was given in relation to information concerning Witness 268, the general principle set out in the ruling is also applicable to other witnesses. The point of principle here is that the VWU is an independent, impartial unit, tasked with determining what is reasonable in the expenses required of the court in the protection of witnesses. The reasonableness of the VWU assessment, especially in the new socio-economic context of a place to which a witness has been externally relocated, it's not undermined by the possibility that particular witnesses, perhaps not every witness, may well view the prospect of such assistance or its actual delivery as remarkably impressive, given the circumstances of the socio-economic context from which the witness has been relocated. Whether or not any witness is impressed by the assistance or the prospect of it in that way remains a matter for legitimate questioning by counsel without prejudice to the VWU's assessment as to the reasonableness of the assistance. Of course, the principle applies both to internally relocated witnesses and to externally relocated ones. It may, of course, be argued, as appears to be the case in the matter of this application, that there is little or no apparent prejudice if all that the VWU is required to do is provide the requested information in the manner of generalized figures of the expenses, without their detailed particulars. The Chamber is not impressed by that argument, for to be fit for its intended purpose, the information needs to be appreciated in its full context, and that poses a risk to the witness protection program, a prospect that is not acceptable to the Chamber. And in the absence of the fuller context, the generalized information as to expenses poses the risk of being misleading. That prospect also is not acceptable to the Chamber. For the foregoing reasons, and based on the information currently before it, the Chamber rejects the request for disclosure of expenditure by the VWU. That is the ruling.
As court pleases.
Witness, welcome back. I see you are there standing or sitting ready for Mr. Steinberg to continue. Thank you very much. And Mr. Steinberg will now continue his examination in chief.
Thank you, Your Honours. Good morning, Mr. Witness.
Good morning.
I'd like to continue just examining circumstances surrounding your attesting to the affidavit on the 11th of August this year. And I'd just like to get some background, please. Is it correct that you were due to travel to The Hague to testify, or travel to The Hague on the 2nd of June this year to testify during an earlier session of this court?
No.
What are you saying? Were there no arrangements made for you to come to travel to court?
Yes.
Sorry, so there were arrangements made for you to travel to the court?
You are talking of 2nd June.
Let me put it a bit more succinctly. Were there not arrangements made with you, in fact, to travel on the 1st of June to arrive in a location I won't mention in public session for the purposes of handover to VWU to travel to The Hague to testify? Remember those arrangements being made?
No.
I put it to you that, in fact, you were due to travel on the 1st of June, and in fact, as late as the 28th of May, you confirmed that you would be traveling for handover to VWU to come and testify, but that you never arrived.
Mr. Steinberg, can you break it up? You're cross-examining the witness, and that is overloaded with
As the court pleases.
more than one proposition. While you think about breaking up that question, 1 minute, I understand that Mr. Mutai, you had put in a request to address the chamber. Is that the case?
Yes, Mr. President.
At what point were you hoping to do that?
Mr. President, I was a bit unhappy about the kind of questions my landed
Let's not get into your submission now. I'm saying, is this something that can wait a while?
Mr. President, I am prepared to be guided by the court, but if it is something that my learned friend does not bring up again, I will not. I'll let it rest.
All right. Well, then, in that case, let's proceed and see if at any point you feel a need to come in and submit. Let me know.
As it pleases the court, Mr. President.
Thank you. For now, let's proceed with Mr. Steinberg's question.
Thank you, Your Honours. I do observe, of course, I'm not sure which areas it is my learned friend has concerns about, so I'm unable to be guided without that information. But
Keep going with your question. He will let us know.
as the court pleases. I put it to you, Mr. Witness, that in fact arrangements had been made for you to come and travel to The Hague to testify during the June session this year. You dispute that?
Yes.
And in fact, on the 28th of May, did you not send an SMS to one of the investigators telling him that you would travel to Nairobi on Sunday and arrive at the handover destination the following Monday?
No, I don't remember.
Well, is this something you might have done and you've forgotten, or do you dispute that anything like that ever happened?
I really don't remember sending an SMS on May.
Well, if, as you say, no arrangements had been made for you to travel to The Hague, I presume there's no reason, would be no reason for you to send such an SMS, would there?
Yes.
I see. Well, I put it to you that despite these arrangements, you failed to travel on the, well, you failed to arrive at the destination on the 2nd. And despite many attempts to get hold of you, we couldn't contact you telephonically. Isn't that true?
Yes.
That is true.
Yes, it is true.
All right.
Mr. Steinberg, 1 second. We will go into private session for a quick minute.
We are in open session, Mr. President.
Thank you, Your Honour. When did it first come to your attention that a summons had been issued for you to appear before this court?
It was August this year.
And how did that come to your attention?
I read it in the newspaper.
Could it perhaps have been sometime in July that you found out about this?
If not July, it is August.
And when you found out that the summons had been issued for you, is it correct that you then made contact with the OTP again, with the prosecution?
Yes, I made.
And if I put to you that on the 18th of August you sent an SMS to a member of our field office in East Africa, reading as follows: Hi, spelt H-A-E. Well, I'm going to read out what I believe it says, and then I'll read the shortened version. But it seems to read, Hi, would it be possible for, and then you name a member of the OTP staff, to call me, tell him to do so, thanks. For the record, it's H-A-E. If it, for would, is abbreviation to W-L. Possible for the person to call me, C-A-L, tell him to do so, T-E-L. You remember sending such a message?
Yes.
And is it correct that the person you wanted to speak to then called you back and you told him that you saw on the internet that you had been summoned? Is that right?
Yes, I told him I saw in the paper.
All right, well, according to my record, it says you told him you saw on the internet, but we'll leave that for the time being. And is it correct then you wanted to know if the decision could be reversed and if you could come and testify voluntarily? Is that right?
Yes.
Why did you do that?
Sorry?
Why did you want to come and testify voluntarily again?
Yeah, because I wanted to come and tell the court the truth.
What truth is that?
That what I had given in the statement was false.
I see. And is it correct that from the 18th of July throughout the rest of July and into August, arrangements were made by the prosecution and the VWU in preparation for you to come to testify during this session on the 1st of September?
Yes.
And is it correct that up until the 8th of August, you had been in contact with members of the prosecution and the VWU, and you hadn't indicated to them any problem about coming to testify?
Yes.
And you hadn't made any mention about the fact that any of the evidence you'd given in your statements was false?
Yes, I had not told them.
So you just told the court that you wanted to come and tell this chamber the truth as of the 18th of July. But yet, when you were due to travel on the 10th to meet VWU on the 10th of August in order to travel to The Hague, you didn't arrive. What made you change your mind?
During that time, I had to consult my religious leader, who is a priest. And then I informed him that sometimes back last year, I made a group of investigators whereby I had to give them a false statement. So after wide consultation with the religious leader, he told me that it is not good for you to testify which things which are false. It is better you say the truth so that the truth will set you free. So from that time, I didn't see any need now to travel, but just to wait. Then I can come and testify in Kenya and tell the court the truth.
So you were planning to come and tell the court the truth when you contacted the OTP on the 18th of July. Is that right?
Yes.
So how did this consultation with your religious leader change your mind about that?
After it had been said that the summons have been issued, I didn't see any need of traveling to the ICC. I saw it was better even to testify here in Kenya, because the same thing I will go and say in the ICC is the same thing I will just say here in Kenya.
So it was finding out that the summons was issued that made you change your mind about traveling. Is that right?
Yes, after the summons had been issued, I saw there was no need to travel.
But, sir, I don't understand. You told the chamber that you already knew about a summons being issued for you before you contacted the ICC, the OTP. Isn't that right?
Yes.
And at that stage you intended to travel to The Hague to testify, correct?
Yes.
So what made you then change your mind to stay in Kenya to testify?
Yes, I said I didn't see, by that time I never saw any difference testifying in The Hague and testifying here in Kenya. So I found it that I'll be comfortable to testify here in Kenya.
So was it your consultation with your priest that was the turning point in your deciding not to come to testify?
No, I just went to him for consultation, that what should I do? And then he told me just go and tell the truth in the court. And then it was my own decision that let me testify here in Kenya.
And of course, I don't know if you need to have another look at your affidavit, but there's no mention of any consultation with your priest in your affidavit, is there? It's the first time we hear of this.
I think as I had said earlier, my main intention of putting consulting the priest was my personal view, and I couldn't put it in the affidavit. In fact, I had not even tell my lawyer that I consulted a priest. So my aim to put the affidavit was a general document to show that I had recanted my statement, and I was not willing to. I was not no longer willing to go by what I had said earlier.
When did you consult this priest?
Sometimes in the first week of August.
So before the 8th of August then, when you had last contacted the VW and the prosecution and advised them you were going to travel, is that right?
Sorry?
You confirmed earlier, if I'm not mistaken, that you spoke to members of the OTP and the VW on the 8th of August, confirming that you would travel to Nairobi on the 10th. Isn't that right?
Yes.
So now you're saying you spoke to the priest before that, the first week of August?
Yeah, it was somewhere there in that early August. I cannot remember the exact date.
And yet you still at that stage didn't mention to the prosecution or the VWU that you no longer wish to travel to The Hague?
Yes, I didn't tell them.
Why not?
I didn't have any reason.
Isn't it true, sir, that sometime between the 8th of August and the 11th of August, when you attested to your affidavit, somebody contacted you and persuaded you not to come?
We are in open session, Mr. President.
Thank you, Your Honours. Mr. Witness, we were discussing your telephone contacts with the prosecution prior to your meeting on the 6th of July 2013. Is it correct that during the course of these conversations you also had certain discussions, for instance, about your security situation? A number of questions were asked about security, is that right?
Yes.
And what's known as a BSQ, Basic Security Questionnaire, was completed with you telephonically? Correct?
Yes.
And is it not also correct that questions were put to you in what's known as a screening to determine whether you in fact had any information which might be relevant to this case? Is that right?
Yeah, some questions were asked.
And when you were asked these questions by the investigators, did you give them certain details of events that you had witnessed in 2007 and 2008?
I don't remember giving them.
And would you dispute that the date of this was, of the telephone call in which the screening was conducted, was the 27th of June 2013? Does that sound about right?
We never spoke once. We spoke for quite a long time.
Would you dispute that one of those conversations was on the 27th of June 2013?
I don't remember the date. It is unless I go and produce my phone call records.
All right. If the prosecution has a record of that date, would you dispute it?
I can't say anything unless I produce mine.
Mr. President, could I make a request, please, of the prosecution that when they are putting questions, it'd be very helpful for us if they can refer to which tab they are relying upon for putting the questions. For example, there was reference to BSQ. I haven't got BSQ. I think, but it takes a bit of time to find what document, and it would help focus our own information. Similarly, questions were put regarding an SMS. I haven't got the SMS to hand. So if my learned friend can refer to the tab, he's obviously got information that is the basis of questions. We should also have that information. And I don't think...
that is, Mr. Ken, that's a good observation. Prosecutor tried to do that.
So,
I, too, had to be wondering. I did not want to interrupt you in the middle of a question. I was wondering where the text message was on the tab. Just try and point us to it.
Certainly. Your Honours, the text message is contained in an investigator's report, which is at tab 65.
We can move on now, but
yes, well,
for other questions based on something that's on your bundle,
as the
try
court
and point
pleases.
us.
But, Your Honours, for future readers of the record, I may just say that the ERN is KenOTP 01380501. The basis of my current questioning is to be found... what's the screen at? Well, the ERN I'll read out in the meantime is KenOTP 01060965. I've just lost my place, but which was it? Screen at? Down here. There. Tab 34, Your Honours.
Your Honour, I think in our binder it's 24, but I'm not sure. Your Honours, I do formally ask for disclosure of the SMS. We've seen the prosecution in other cases take photographs of SMSs and preserve them. I haven't, although my learned friend's point is that it's included in the investigator's note, the complete SMS has not been read into the record. I think it should have been, but at the very least, as it's the basis of question that's put to impugn the credibility of a witness, we say we're entitled to that disclosure, and I formally request disclosure of that SMS without delay.
Your Honours, the SMS was sent not to investigators at headquarters. It was sent to a member of the field staff who recorded it in a note and transmitted the text verbatim to the OTP. We do not have access to the original text message.
Yes.
That was an important matter that should have been made clear at the time, shouldn't it?
Well, perhaps, except if the witness had disputed that he sent such an SMS, but of course he admitted that he did.
Your Honour, that's not correct at all. It's false.
No, Mr. Steinberg, you need to make such distinctions. But now that's on the record that you did not actually have the actual SMS. It was based on a report to you by your field officer. All right, please proceed.
Mr. President, with your permission, may we also observe that the PSQ was not disclosed to the defense?
Your Honours, the BSQ deals with security matters relating to a witness. It is routinely not disclosed for obvious reasons unless there are any...
But if you're going to ask witnesses questions on the basis of that, you have to disclose it.
Your Honours,
one or the other.
if I had asked any questions on the basis of the contents of the BSQ, I certainly would have. All that I wanted to establish, and I was leading towards the screening, was whether there had been various other discussions besides the arrangement of dates. And I was leading to discussions about security issues. I didn't go into anything that the witness said during those discussions. And from there on, it was a segue into the issue of the screening note. So the contents of the BSQ, in my respectful submission, are completely irrelevant to the present discussion.
Mr. President, can I note, I think it's a matter of principle here, in our respectful submission, if the prosecution, they have a choice in conducting the cross, and if they wish to cross-examine in relation to a document, we have a right to disclosure of that document. Your Honour, the prosecution can't have it both ways. We have a record that in relation to other prosecution witnesses, the BSQ has been disclosed. So they can't now spray and aid a matter of principle that there's something precious and unique and sensitive in a BSQ to the extent that it can't be given to a defence team bound by a code of conduct. Your Honour, it's been given previously, it was referred to now, it should have been given now as well.
The interpreters kindly request that attention be paid to overlapping speakers. Thank you very much.
What was done with the BSQ, we will see later on if there's a need for more than that. Let's proceed, Mr. Steinberg.
Thank you, Your Honours. So, regardless of the exact date of the screening conducted with the prosecution, you won't dispute that it was before you met the two investigators we've been discussing on the 6th of July. Is that correct?
Yes.
And, Your Honours, may I ask, we go briefly into private session. I just want to talk about individuals.
Private session.
When you, just an introductory question. When
Mr. Steinberg, please.
Sorry.
We're in open session, Mr. President.
Mr. Witness, you've while we were in private session, told the chamber that, in fact, the two investigators who spoke to you during the telephone screening at that stage had asked you to give evidence fixing the two accused. You confirm that?
Yes.
My question is, why is it that a few moments ago, when I asked you quite clearly whether the first time you were asked by OTP investigators to fix the two accused was when you met them on the 6th? Why did you confirm that if, in fact, there had been a previous request?
I didn't get you well. I thought you were talking of me meeting them face to face. I never thought of the telephone conversation.
Uh-huh. And when you gave your affidavit to Mr. Matai, you didn't think of it then either, did you?
Sorry?
When you gave your affidavit at the offices of Mr. Matai, you didn't think about it either, that you'd been requested on the phone to fix the two accused?
I never talked of the phone calls.
Why not?
As I had said earlier, that the affidavit was too general to give details of each and every account that took place.
General is one thing, Mr. Witness, but I put to you that, according to your current version, the affidavit was inaccurate in a number of critical details.
Mr. Steinberg, you will know whether you're not beginning to argue with the witness.
Yes. Well, all right. Let me move on, Your Honours. Now, during this phone screening, do you recall telling the investigators about the Harambee in Kaptabi school around the 19th of November? Did you mention that?
I don't remember mentioning.
If it's recorded in the notes of the investigators, would you accept that this is something you might have told them about?
Sorry?
If the investigators have made a note of what you told them, and that note includes the fact that you believe in November, possibly around the 19th, you attended a fundraiser, brackets Harambee, at a school in Kaptabi, near Turbo, would you accept that that is something you may have told the investigators?
I said I don't remember telling them.
Mr. President, the witness has said that. It can be quite simply, I don't object if my learned friend wishes to show the screening note and ask the witness, is that broadly what transpired? There will be no objection from the defence, and then, of course, questions can be put regarding the content.
Thank you, Your Honours. If there's no objection from the Sang defence, I'll take my learned friend up on that offer.
We will not object, Your Honour.
Mr. Court Officer, can you please call up the item KenOTP 01060965? Is it a redacted version? Note 34. It's unredacted. I understand it's unredacted.
Tab.
According to my list, it's tab 34, Your Honours.
Mr. President, it's 25, I think, of ours. 25.
The document is
24.
being presented.
So, may I just inquire from Your Honours, there seems to be a discrepancy in the tabs. I'm not sure if they've been mixed up or if they were incorrectly tabulated. Is it 24 or 34 in Your Honours' binder?
At tab 34, 4 of mine, there is KenOTP 01060965. Is that what we're looking at?
Indeed, that's the correct document, Your Honours.
And
Your Honour, could I just ask at the break, I don't want to delay matters, but we've been given tabs that correlate with Your Honours and the prosecutions. So and you bind us, please, with the identical tabs, so we're not at cross purposes.
Mr. Keegan-Caffel, where does yours fall in?
Mine is similar to yours, Mr. President.
Tab 34?
Yes. Yes.
Oh, right.
Your Honours, we can provide an index. I'm sure my learned friend is capable of rearranging the documents himself.
Your Honour, no, I think this, we do the courtesy of giving my learned friends for the prosecution properly paginated bundles. I know it takes some work, but Your Honour, we're about to finish with this witness and start, hopefully, cross-examination. I'm not asking for too much with the prosecution front office and the back office for somebody to take the trouble to do the service that we provide my learned friends to give a properly paginated bundle. Your Honour, I don't want to waste our time trying to do something that should have been done properly the first time.
I noticed that there are a number of people in the team for both the prosecution and the Ruto defense that certainly should be possible for 2 members of this team to get together and co-relay these tabs.
Yes, Your Honour.
Yes.
I'll ask my case manager to sit with the defence case manager and make sure it's right. I note that everybody else's bundle appears to be correct.
Yes, let's proceed and do that at the break.
Thank you, Mr. Court Officer. Is that document up?
Yes, I confirm the document is being presented to the witness. First page.
Mr. Witness, while we've been talking amongst ourselves, have you had an opportunity to read through that document?
I haven't read.
Well, let's take it paragraph by paragraph. The first paragraph reads, investigators, and 2 names appear, screened the potential witness. We're in open session, yes. So I'll call it the next person, investigator number 1, explained the disclosure procedures and voluntariness. The potential witness agreed and stated that he was willing to give a statement and to appear in court. He explained that he was in, and you give a location, before and during the 2007-2008 PEV there. And then we get to the Harambee. He believes in November, possibly around the 19th, he attended a fundraiser, brackets, Harambee, close brackets, at a school in Capta Bay. And I think I can say actually in public, near Turbo. Ruto spoke at this event. He said that anyone who supported the PNU was mad and should be taken away. Ruto added that if the ODM lost the elections, they should be prepared to drive the Kikuyu away. Do you now recall mentioning the Harambee during the screening?
I don't remember.
All right. You go on to say in the next paragraph, in December 2007, he attended an ODM rally in Turbo. Ruto was one of the speakers. Do you remember telling them about that?
I don't remember.
All right. 2 paragraphs down at the bottom of the page, you state about a week before voting day, you attended a meeting at Ruto's house. Do you remember telling them about that?
I don't remember.
Mr. Court Officer, please call up the next page, 0966.
Talking to investigators, telling them all this.
All right. I'm now asking you about this pamphlet. Did you ever have a pamphlet in your possession threatening PNU supporters?
No.
All right. See, what I'll put to you, sir, and I'll then move on, is that the reason why you've been changing your evidence about who and when you were requested to fix Mr. Ruto is because your affidavit made at Mr. Mutai's office cannot explain the fact that as early as the 27th of January, beg your pardon, 27th of June 2013, you had already given important details of your version to the investigators. You understand?
Sorry?
I put to you that the reason why you've been changing your evidence as to when you were told and by whom you were told to fix Mr. Ruto is to explain the existence of this report on the 27th of January. Isn't that so?
I think I have not changed any of my statement.
The reason why you've had to implicate the lady in manufacturing evidence is because either you realized or somebody told you that prior to your meeting on the 6th of July, you had already created a record of your version. Isn't that right?
We have not. I didn't even discuss with anybody about the lady and about meeting those people. It was from my own because I knew what happened to me.
The final proposition I'll put to you in this regard is that if things had happened as you now say they had, that you'd been requested to fix the two accused by investigators during your telephone screening and by the lady, that important detail would not have been omitted from your affidavit. Isn't that so?
I think I'd say that when I was giving the story to my lawyer, I didn't have the statement with me, and I was just giving an overview of what had happened.
And how would the statement...
When I was giving the statement, I never knew it that it was going to be used against me. I could have kept the records.
There's nothing in your statement to the investigators on the 6th that mentions anything about the lady or about being asked to fix the accused. Isn't that so?
In my statement.
Yeah?
Is it in my statement or on my affidavit that you are talking about?
You mentioned earlier, when I challenged you on the fact that the lady is not mentioned in your affidavit as being the person who first told you to fix the accused. All right? Your answer was that you didn't have your statement with you when you made the affidavit.
Yes, I didn't have the statement with me.
And how would the statement have helped you to remember that it was the lady who asked you to fix Mr. Ruto, and not for the first time these two investigators?
I think I said in that...
Mr. President, I'm sorry for interrupting the witness. I apologise. Your Honour, I'll leave it to the bench, but we've been really going around the houses. The witness has said repeatedly about the role that the lady, he says, played, about being recruited and what was said. And my learned friend, to keep going back to a point where the bench have more than sufficient evidence to make assessments on that issue, on that particular issue, really is becomes irrelevant questioning in our respectful submission.
Stand by, proceed.
Thank you, Your Honours. I had, I think, exhausted that issue.
A private session.
We're in open session, Mr. President.
Thank you. And we will take our morning break now, and we will come back in 30 minutes. The witness, you're still on the witness seat, and you'll rejoin us in 30 minutes.
Okay, thank you.
Court will rise.
All rise. We will